initiated a program called Masters in International Peace and Security, which was jointly taught by faculty of both the School of Law and the Department of War Studies. And I found just an hour ago that it still exists. So that creation from my time at King's in mid-90s is still there. So my big privilege and honor to welcome Guillermo to our class today. And this is also a joint class between my course called Law and Practice of the United Nations and the Jindal Society of International Law, which very kindly invited you to talk to us today. And the topic cannot be more timely because what we have experienced in the last 5, 6, 7, 8 years is a shift in many parts of the world towards more nationalism, populism, xenophobic feelings, which actually affected also the political spectrum. And in many countries, even some of them we used to consider to be pioneer of change in Eastern Europe, such as Hungary and Poland back in late 80s, now have become, unfortunately, authoritarian. And we have also tendencies everywhere else with Brexit, with the election of Donald Trump in the United States, with the election of Jair Bolsonaro in Brazil, and few other countries. We have experienced something unprecedented shift back or backlash, where achievements which we all celebrated in the 1990s have been reversed recently. And the question comes, what does it mean for international relations and international law? So we are very much excited to hear from you, Guillermo. So next to speak is you, and you have your time with our students, and then Ankit will moderate the question and answer session. So we are all excited, as I said, to have you with us today. Hopefully next time you can visit Jindal and be with us in person after the coronavirus is over. Thank you once again, and your lecture starts now.
Well, thank you very much. And yes, I would have much preferred to be there with you in person, but unfortunately the circumstances are what they are. And let me thank the Jindal Society of International Law, the Center for the Study of the United Nations, and you, Professor Popovski and Professor Malhotra, for your very kind invitation. And also to thank Ankit Malhotra, who has been extremely efficient at coordinating with me. The Masters in International Peace and Security is still very much there, as you rightly spotted, and it's a great success. I think of all the various masters that the War Studies Department offers, it remains one of the most successful, and it depends on that very close collaboration with the law school. So we're still very much offering it, and very glad to offer it. I think when it first came about, as of course you very well know, having been a protagonist, it was the time when international peace and security was re-emerging as this concept in the Charter was all of a sudden in the 1990s taking center stage again, and it obviously remains central to the practice of international law, and it has grown and developed since those days. So thank you once again very much for this invitation and for giving me the opportunity to be with all of you here. And when I was first approached to give a lecture, the topic that was suggested to me was reimagining international organizations, and it was an excellent suggestion, and I think a very good fit with my academic research. I've written on the law of international organizations, I've written on the practice of international organizations, and I've always been particularly interested in situations where international organizations exercise functions and powers that are governmental or quasi-governmental in nature. So I wrote on the direct administration of territory in Kosovo or East Timor. I wrote on the running of emergency operations by UN agencies and on the administration of refugee camps, and at the regional level on the experience of the European Union. These cases, which are obviously very different, what they have in common is that they all test the idea of international governance because they involve the exercise of public powers by actors other than states. Now, as you know, I chose a different topic for my lecture today, and the title is International and the Future of Democracy. But it is a topic that has a lot in common with what had been initially proposed. International organization and the future of democracy are, I believe, deeply intertwined questions. And reimagining international organization is what is required if we want to develop an international system that ensures the flourishing of democratic values and political liberty. So they're very much related questions, international organization and democracy. The first person intuited this relationship and this tension potentially between political liberty, democracy on the one hand, and international organization was the Swiss philosopher Jean-Jacques Rousseau. In the Emile, which he wrote in 1762, he wrote that one of the most important questions in political philosophy, one that he thought would come to define political and philosophical argument in the future, was how far can the rights of an international federation be stretched without destroying the rights of sovereignty. When Rousseau wrote the Emile, modern international law wasn't anything like it is in our days. It was still in its infancy, and there were no international institutions. There were others before Rousseau who had called for the creation of an institution above states, which they sometimes called a federation, other times a confederation. And what these projects had in common was the idea that international institution, that an international institution had to be created and endowed with a degree of political and legal authority over states if international law was to, so to speak, come of age. There was a growing recognition in the 18th century, the century of the European Enlightenment, that the problem of peace could not find a lasting solution within a thin system of international law, such as they had at the time, one based principally on custom, with no institutional apparatus and with no enforcement other than self-help. But I think few people before Rousseau, and I dare say not many since Rousseau either, understood that this very worthwhile upgrade of international law into a more complex and ambitious legal system with more diverse and complex lawmaking, with institutions and with enforcement through courts and through other methods rather than just self-help, was going to pose a challenge to the value of political liberty. There was, of course, one great thinker who, a few decades after Rousseau, tried to grapple with these questions, and that was Immanuel Kant. And in his famous essay on perpetual peace, he considered the idea of an international federation that would be, in effect, as he called it, a world state, a Weltstaat, a cosmopolis in essence. And it is evident from Kant's essay that he found this idea very attractive at some very profound level and quite convincing in many ways. And some scholars think that cosmopolitanism, belief in a world state, was really logically consistent with Kant's own moral and political philosophy. But in the end, to the surprise of many, Kant rejected cosmopolitanism. He says in a very important passage of that essay that a world state would mean soulless despotism. And the problem that he had was that he couldn't really find a way of reconciling those two values that Rousseau's question had juxtaposed. He could find no way of preserving the most precious moral and political value associated with sovereign statehood, namely political liberty, with a cosmopolitan order understood as a world state. He still very much believed in international institutions, and in particular in an international federation. He was an internationalist without a doubt, but he was not a cosmopolitan. And this is a very important distinction between internationalism and cosmopolitanism that many supporters of international law sometimes miss. There was a recent documentary on BBC Radio 4 entitled The Dream of World Government, presented by the UK's former Foreign Secretary, David Miliband, which illustrated, I think, the extent of this confusion. That documentary, he didn't seem to distinguish between internationalism and cosmopolitanism, and seemed to think that inevitably every internationalist would also embrace the vision of a world government. And that, I think, is a profound confusion, because it really doesn't engage with the complexity of that question first identified by Rousseau, and with the skepticism that many liberal internationalists, including Kant, had with the full-blown idea of world government. Now, international law has obviously expanded enormously since Rousseau's time, and it has developed in ways that were not quite foreseen by those thinkers. International institutions are no longer figments for the imagination of philosophers, but they are a political and legal reality that defines our time. We don't, of course, have a single international federation or confederation, which is what in the 18th century people were imagining. What we have instead is a variety of international and regional institutions which possess different competences and different degrees of legal and political authority over their member states. Now, there is, of course, one global institution that in some ways resembles that international federation imagined by philosophers in the 18th century. But I think for reasons that will be obvious to any student of international law, the United Nations is not a federation, although it does have some confederal features, perhaps. So adapted to the reality of international law such as it is today, Rousseau's question would be, have the rights and powers of the contemporary system of international law and of its institutional actors been stretched to the point where national sovereignty has been damaged or destroyed? How is the balance between the international order and the domestic order in terms of the values that each represents being struck? But I think before considering this question, not in an abstract philosophical sense, but in light of the current system and practice of international law, it is perhaps important to dwell on a preliminary conceptual and normative question, namely, what is sovereignty and why should we be concerned with it? Sovereignty has become a bit of a toxic word in recent years, and it is associated for not without a good reason with populist political movements in Europe and in America in particular, and even with enemies of a rules-based world order. And in some languages, new words have entered the political vocabulary, such as souverainisme, to defend those who defend sovereignty in a sort of nationalistic sense. Now, the curious thing about this change in the sense that the word sovereignty has within an international context is that until only 30 years ago, sovereignty would not have come with such a negative baggage, particularly when it was associated with the people. The idea of popular sovereignty until 30 years ago would have been viewed as a progressive idea by liberals and by people on the left and on the liberal right too. So there has been a change in the way in which we perceive the value of this word sovereignty. As I said, it has become in some ways toxic. And why did it become toxic, and why, and what does this tell us about modern day internationalism? I think in international law, we traditionally think of sovereignty as state sovereignty. That's the sense that sovereignty traditionally has for international lawyers. But a very important change began to happen at the end of the First World War and then with the UN Charter, when the principle of self-determination emerged as a principle of international law and with the UN Charter became a centerpiece of the new world order. With self-determination, a different sense of sovereignty centered on the people rather than the state found its way into international law. Self-determination, that is the pursuit of collective political liberty and of self-government, was the driving idea behind the national liberation struggles in Europe against the Ottoman and Habsburg empires, and then, of course, in the 20th century against the European colonial empires. Uncertainty on the exact scope of self-determination persisted until decolonization in the 1950s and in the 1960s. But at some point, through the practice of states and through the practice of the political organs of the United Nations, self-determination became even more firmly established as a fundamental principle of international law and as a principle that had at its heart the right of every people, in the words of the International Bill of Rights, Article 1, common to the two covenants, to freely determine their political status and to freely pursue their economic, social, and cultural development. It is true, of course, that neither the Charter of the United Nations nor the legal developments that accompanied the process of self-determination elevated self-determination to a principle of democratic self-government. There is still a difference in modern international law that we can't ignore between the legal content of self-determination and democratic self-government. We must be careful not to confuse the two. Nonetheless, I think it is fair to say that through self-determination, at the very least, an idea of popular sovereignty, albeit perhaps not yet an idea of democratic self-government, began to flow through the veins of international law. Now, contrary to, I think, widespread perceptions, the world order that the UN Charter was not premised on the sort of outright rejection of sovereignty. It was still fundamentally founded on sovereignty, but in a more purposeful way than had been the case before. The UN Charter did not create a system of international law that was souverainist in the sense that it admitted of no higher authority than the sovereign state, for such kind of souverainism would be not only inconsistent with the Charter, but is simply impossible to recognize with any idea of international law. The idea underlying the Charter was one of state sovereignty that was relative, that was constrained by international law in important ways, particularly when it came to the rules on the use of force, but also an idea of sovereignty that was deepened by a sense of purpose. And that purpose was the flourishing of human communities through the advancement of self-government, of self-determination, and human rights. So the sovereignty of the state thus conceived was not an end in itself. It was relative, it was limited by international law, but it was also instrumental to a higher purpose. And that higher purpose was the advancement of human rights and the flourishing of human communities and their economic and social development. So this was the rather more complex understanding of sovereignty that emerged from the Charter. And it was not at all, as I indicated, contradicted by the fact that the Charter itself curtails state sovereignty in some crucial ways. And most importantly, sovereign states with the Charter lost the legal power, if they ever had it, to wage aggressive war. Interestingly, the post-war constitutions of the defeated Axis powers, Germany, Japan, and Italy, mirrored this understanding of sovereignty in the Charter, by providing for both the renunciation of war as an instrument of state policy and for popular sovereignty as the foundation of the new constitutional orders. So you have this transformation of the idea of sovereignty with the Charter in two ways. On the one hand, it ceases to be absolute, it becomes relative. There are clear constraints that the international order imposes on sovereignty, but it also becomes instrumental. It isn't just the sovereignty of the state that is fetishized for the sake of itself, but is the sovereignty of a state that is meaningful because it promotes important values that the international order recognizes and gives protection to, such as development, human rights, and self-determination. Now, with the fall of the Berlin Wall, many predicted that international law would take a more decisive democratic turn and complete the sort of revolution that had begun with the Charter. And there was probably no better moment for international law to embrace more fully a democratic ideal, an ideal of self-government, rather than the sort of incomplete self-determination such as we have it, than the period that followed 1989. Now, the curious thing is that in many ways, democracy doesn't seem to have made much progress as a principle of international law since 1989. I think there are arguments based on the purposive and evolutive interpretation of self-determination and human rights that can be made in support of democracy now, and those arguments are not really all that different from the sort of arguments that would have been made, that were being made by people like Thomas Frank already in 1989. And those arguments will probably be met with very similar objections in terms of positive law now as they would have been back in 1989. So in other words, there doesn't seem to have been the kind of radical change, whether through the adoption of a new multilateral treaty or through the emergence of new custom as a result of state practice, that would allow us to say today definitively that a democratic principle is crystallized in international law in a clear sense, let alone that it has become a central part of it. So an important question is really why this sort of 1989 promise of or expectation of a democratic turn in international law failed to bear fruit. And I think it is an acutely important promise for the reasons that Professor Popovski highlighted at the beginning. It's acutely important now because of the changes that have been happening over the last few years, or the political changes that have been happening over the last few years, and the sort of autocratic turn that we are beginning to witness. So why couldn't we do better between 1989 and, say, the financial crisis, when there was this window of opportunity, and why are things now taking a turn for the worse? I think these are important questions about the recent history of international law, but also questions that are connected with that question that I identified initially as Rousseau's question. In other words, this tense, crucial relationship between political liberty and the international order. Now, in addressing these questions, I think I've often found myself going against what it seems to me has become a bit of a standard account on the development of international law from 45 until the present. And this standard account suggests that the end of the Cold War injected new life into the rules-based order which the framers of the Charter had envisaged, and key elements of that order, which had existed only on paper, most notably the powers of the Security Council under Chapter 7, were implemented after the end of the Cold War. The international trade regime that had only been partially developed after 1945 was upgraded after the end of the Cold War, and its reach was obviously expanded through the creation of the World Trade Organization, the inclusion of China. New international courts and tribunals were set up while those already in existence, such as the International Court of Justice, became much busier. These were the steps that on the standard account advanced and in some ways completed that original mission that had begun in 1945 and paved the way for the emergence of or the strengthening of a liberal international order. Now, there is much that I agree with in this account. I think it is evidently the case that key aspects of the UN Charter, particularly when it comes to collective security and international peace and security in particular, were revitalized thanks to the end of the Cold War. But it is also, I think, and there's something missing in this account. And I think what is missing is the rupture, or at least the tension, between some of the principles and values enshrined in the Charter and in that idea of relative and purposeful sovereignty on which the Charter was premised, that I set out at the beginning, and a new set of ideas that began, and practices that began to emerge after 1989. As we've seen, the Charter was premised on balancing these two competing elements, really the two competing elements in Rousseau's equation: the authority of international institutions and the rights of national sovereignty. The Charter took away a considerable degree of sovereignty from states, but it also preserved sovereignty and gave it a new sense of purpose with self-determination, development, and human rights. And it is, of course, important to remember that these developments, it's something that perhaps I should have mentioned before, that these developments were far from uncontested. Western states, and in particular the former colonial powers, Britain and France, less so perhaps the United States, resisted the notion that self-determination gave people's rights for a very long time. The UK's position, I think, in its practice until probably the late 60s, was that self-determination was a political principle, but not a right. Now, this battle was lost by the end of the 1960s. Self-determination emerged as a right to be free from colonial oppression at a minimum, and probably as a right to more than that, as we have seen in light of the definition in Article 1 of the International Bill of Rights. Now, self-determination in its internal dimension, in its sort of self-government dimension, was also met with resistance in the Cold War era from the Soviet bloc that didn't really appreciate the idea of self-determination becoming a vehicle for democracy in a kind of liberal or Western sense. So you had these two sources of resistance that operated against the development of this principle, one coming from the former colonial powers and the other one from the Soviet bloc. But be as it may, by the end of the Cold War, this principle had developed very considerably, as I indicated before. And it is also the case that in the period after the end of the Cold War, democracy made considerable progress in a lot of countries in the world, from Eastern Europe to Latin America or Africa. Authoritarian regimes collapsed and gave way to regimes that were, in some cases, perhaps imperfectly or partially democratic, in other cases, to truly fully democratic regimes. And yet, as we saw before, international law wasn't really affected by these momentous developments and the sort of rapid expansion of democracy between 89 and roughly 2008 or 2010. So the irony is that as more countries were becoming democratic, the international order wasn't really paying the sort of attention to the democratic principle that one would have expected, given the hegemonic role also that democracies had at this point, at least until I think the financial crisis. So I think the answer to this question as to why the decisive turn after 1989 towards democracy didn't happen can't be found in the fact that democracies didn't dominate international affairs, because for a long time they did. The answer, I think, is rather more complex, and it has to do with a number of important events, including, I think, the huge distraction that became the war on terror and the invasion of Iraq, which essentially meant that it was only 10 years, the 1990s, that where this big turn could have taken shape, because from about 2001 onwards, the world's leading democracies were distracted by other questions. I think, and I think this has also been hinted at before, this turn into the rise of autocracies, and Tom Ginsburg has from the University of Chicago has been writing about the rise of authoritarian international law as one of the great changes that we've begun to witness since 2010, with the rise of China and the changes in Russia, and also changes in a more autocratic direction that we are witnessing within democracies or former democracies. So all of this is undoubtedly taking place, but it doesn't quite answer the question as to why that window of opportunity was lost. And I think the answer comes, at least in part, by from a transformation in the ideology of liberal internationalism that began to take place perhaps even before 1989. So in addition to all of these forces that and events that we have identified that stymied the development of a democratic principle in international law, the war on terror, and more recently the rise of autocracies, there are two other forces or factors that I think explain this missed opportunity. The first one is globalization, and we're all familiar with it. And the second one is supranationalism. And I think each of these factors stymied in some ways the democratic transformation of international law. And I think to appreciate the role of these factors, we must understand, and this is again going back to the sort of basics of political and legal theory, that liberalism is a complex relationship with democracy. Beginning in the 19th century and then continuing in the 20th, liberalism became more and more open to democracy, but it wasn't always open to democracy. The great fear that lovers of liberty had of democratic rule was that it could degenerate into populism, that it could degenerate into demagoguery. So liberals always had this, not quite skepticism, but suspicion or fear that democracy left unchecked could degenerate into the tyranny of the majority or into populism. So liberal thought took quite a long time to reconcile itself with democracy. And it was thinkers like Constant and obviously Tocqueville who really exemplify liberalism's slow embrace of democracy, cautious at first and qualified, I think, but very, very important. So that I think is a factor to keep in mind by background. I refer to these two forces, supranationalism and globalization. I think I should say a bit more about them. Supranationalism, the origins of supranationalism lie in a mindset, if I can call it that first emerged in Europe after World War I, but really took root in the aftermath of World War II. As I hinted at before, for traditional liberalism, there wasn't really a contradiction between liberal nationalism and cosmopolitan peace, between liberal nationalism and international law. On the contrary, they considered it, the two, as interlinked, and again, Kant famously maintained that the basis of international peace depended on the internal order of states, that free states in essence were going to be at peace with one another. So until the Second World War, there was the sense that national sovereignty, as long as liberal, could contribute to international peace, that there was no necessary tension between the two. The causes of war were considered to be tyranny and absolutism. And in fact, if you look at the preamble of the UN Charter, it still bears testimony to this idea of what causes war. But in the aftermath of the two world wars, a different sense began to emerge in Europe, and which is why I've called it a mindset. And I think that sense was that the 19th century liberal nation state, as the experience of France, but especially Italy and Germany had shown, was too unstable and too fragile. That liberal patriotism, which liberals in the 19th century valued, was always at risk of degenerating into nationalism, and that therefore international peace and international law couldn't be secured within a framework of nation states, even if those nation states remained liberal. Something more was needed, something more profoundly anti-statist was needed. For many, I think, in Europe, from 1945 onwards, the problem wasn't the absolute state, but was the state itself. And the project of European integration drew, I think, moral and political legitimacy from these growing anti-national and anti-statist sentiments. So with this distrust of the sovereign nation state, which I think was very much a European problem initially, or a European perception, for obvious reasons, for the tragic history of Europe in the 20th century, with this distrust of the sovereign nation state came also this distrust of unrestrained popular sovereignty. But again, we need to be careful not to succumb to simplistic narratives, because it would be very simplistic to think of post-war Europe as defined entirely by a sense of distrust of sovereign states and distrust of sovereign peoples. The picture is more complicated, and it is complicated by the fact that popular sovereignty was at the same time in Europe being reinvigorated by the experience of war and partisan resistance. And as we've seen, popular sovereignty featured prominently in post-war constitutions. But you have, alongside this valuing of popular sovereignty, you do have these strong anti-statist beliefs and anti-national beliefs and fears that are also part of the European mind, really, after 1945, and growing alongside these other more sort of traditional forms of liberal beliefs. It's to understand supranationalism, one has to understand these changes that are quite European in a sense, but I think reverberated across the world over time. And there was another change that also ended up affecting ideas about governance, because this is what supranationalism is. It's an idea about governance, taking away governance from state or reducing the role of state and thinking about ways of governing that is different from one that is just based on state, but that sits in important ways above state. This other change is technocracy. Now, there again, one sort of needs to put this change in the wider picture of the history of liberal thought. I mentioned before that liberals were always a little bit ambivalent towards democracy. For 19th century liberals in Europe, the main check on democracy degenerating into populism had to come from the aristocracy. That was certainly the British liberal sense, that the aristocracy were the House of Lords, was the check and balance on the House of Commons. And as Tocqueville understood, the genius of American constitutionalism was to find a constitutional system of checks and balances that sought to achieve that same result of protecting democracy and making sure that it doesn't degenerate into populism without an aristocracy, without a national aristocracy. And that was, through institutions such as the Senate and the Supreme Court. I think the second half of the 20th century, and especially after, again, at this point, America is in some ways intellectually leading these changes and inspiring the world, including peoples under colonial oppression by European empires. The idea of government of the people, by the people, for the people, the Lincolnian idea of liberal democracy, began to be viewed as essentially what liberalism stood for. It stood for an idea of popular government, but within a system of constitutional limits. Now, again, this sense of a popular democracy was not uncontested. What began to happen from the late 19th century in Europe, and then to a lesser degree, or perhaps later in America, was what an American social historian, Christopher Lasch, calls a revolt of the elites. Again, the fear was that government of the people, by the people was too radical an idea, and the limits that perhaps worked in America could not necessarily work elsewhere, and that a more fundamental rethinking of democratic rule was necessary. And I think that change is illustrated in the work of Walter Lippmann, a very important American social thinker, the first of the 20th century, who began to theorize the idea that democracy didn't need, as he put it, to require that people govern themselves. The public stake in government is merely procedural. Democracy can just be process, and public interest should not extend to the substance, as he put it, of decision-making. Decision-making on key questions can be taken in a pure democratic way because the public doesn't know enough to decide on complex policy issues, but the democratic nature of decision-making has to be guaranteed through a series of procedural constraints on decision-making. But when it came to questions of substance, decisions should be left, and I quote from him, they should be left to knowledgeable administrators whose access to reliable information immunized them against the emotional symbols and stereotypes that dominate public debates. So this is, in essence, this idea of technocracy as a check and balance on democracy that emerges around the first half of the 20th century. And its emergence is very timeless because, as we've seen, supranationalism as a different idea of government was also beginning to take shape in the interwar period, but most importantly, after the end of the Second World War. And it is certainly no coincidence that the founding father of the European Union, Jean Monnet, spoke of what he called souveraineté élitaire. It was this idea of sovereignty that was combined with a very important technocratic element, which he thought was the key to a supranational forms of governance. I think Monnet would have obviously described himself as democratic, but he would have described himself as democratic in that Walter Lippmann sense of democracy as process. But he also would have described themselves, and did indeed use these words, as a supporter of this elitist notion of sovereignty. And by that, he did not mean the sovereignty of the aristocracy, nor did he really mean the sovereignty of a meritocracy. Perhaps to a degree he did, but I think he meant the sovereignty of liberal elites from different states connected with one another, joined by a common sense of purpose, operating within a system of rules, treaties, and trying to advance the values and goods that matter to people, peace and first and foremost, but not only. So this is this very fascinating idea of supranationalism that at some point meets technocracy, and that emerges as a very important internationalist ideology, an international way of conceiving, of thinking about government, other than by government from the states. Now the difficulty is, and again we keep going back to that tension that Rousseau identifies, it may well be that the federation, as he calls it, or the international order or the supranational order, it may well be that this vision of an elitist, technocratic, supranationalist and rules-based governance is quite progressive, but it does clash with self-government. And one can try to reduce the idea of self-government to a merely procedural sense, as advocated by Lippmann. But the difficulty with that is that politically, that sense of self-government strikes many Democrats as simply inadequate. It can't just be about process or about procedure. There has to be some substantive involvement in decision-making by peoples for a particular system of government to be able to be described as democratic. So, and that's why I put that Rousseau question at the outset, because it really frames so many of the problems and the debates and the dilemmas that we face today. So that tension between the rights of national to be the first step towards a kind of Platonic worldwide cosmopolis, then the EU itself may be on course to proving this sort of Whiggish prediction a bit wrong. And in fact, I think what has happened in the last few years in Europe is that the EU itself looks more and more like a state. And remember, the initial ambition was to come up with something that wasn't a state, was come up with something that transcended statehood. But faced with the sort of crisis that we have seen, the Euro and Brexit, the rejection of the constitutional treaty, actually even before the Euro crisis and even before Brexit, the European supranationalist idea seems to be morphing into essentially a state-building project. And I think it is no coincidence that one hears more and more often nowadays European leaders, for example, President Macron, speak very openly about European sovereignty. Now, European sovereignty is not a notion that supranationalist federalists liked or promoted, because the idea again was to be post-national, post-sovereignist, not just sovereignist on a continental scale. So that's supranationalism with its complexity and its contradictions, and that I think one has to keep in mind to understand one of the forces that has created a hesitation, or contributed to the hesitation to move international law into a more clearly democratic direction, with some of the world's leading democracies, i.e. European states, committed to a very different kind of project, a very different kind of ambition. I think things were going to be met with some resistance. Now, the other factor that I identified is globalization, and this perhaps needs less explanation. It is perhaps interesting again to recall, to put our minds back to the time of the fall of the Berlin Wall, that the prevailing sense at the time was that not only a new era for democracy, had begun and that a new democratic and liberal international law was going to be ushered in, but also that this new sense of individualism was going to prevail. This intellectual mood found, I think, probably the best expression in Thomas Frank's book, published around this time, on the individual, on the empowered self, law and society in the age of individualism, which contained this prediction that renewed confidence about freedom, about choice, would empower individuals, and that this sense of individual empowerment and the strengthening of liberty and democracy would give a new shape to international law in the post-Cold War era. The prevalent sense, 30 years on from the fall of the Berlin Wall, is quite different from the sense that Thomas Frank captured in that brilliant book. I think far from being more empowered, the individual now appears to be, if anything, more disempowered as a result of social and technological changes that threaten the very notion of personal autonomy. Financial transactions decided by algorithms that operate at speeds that are very well beyond the computing capacity of the human brain. Individuals being harvested for data by big tech, and so that their choices can be manipulated. This new sort of global system of behavior modification, which Shoshana Zuboff, in a brilliant book that appeared 1 or 2 years ago, describes as surveillance capitalism, is not something that in the early 1990s had been envisaged or was being discussed. So we have this disempowerment of the individual together with the globalization of the markets, which is, as I said, a much better understood phenomenon, and one that has been discussed quite widely. The globalization of the market obviously poses a problem for national democracies, for democratic government at the national level, because one of the ways in which governments justify themselves, legitimize themselves, is by the fact that they can regulate the market. But a democracy cannot regulate a global market, a domestic democracy, and so democracies are being delegitimized in important ways by the markets becoming global. And I think it is also important to remember, and I'm aware that I'm sort of going back in time and almost trying to do little flashbacks in terms of debates that took place in the past, but these are such complex issues and they've been debated in different strands at different times that I think to have an informed discussion, one has to do this. There was a point just before the end of the Cold War where a lot of the debate on the future of democracy focused on the failure of democracies to challenge national oligarchies. People like Habermas and people like Bobbio wrote extensively in the 1970s and 1980s about this broken promise of democracy, the fact that national economic oligarchies had proven much more resistant to democratic rule than had been imagined and perhaps even promised. But if national oligarchies were so resilient in an era when national democratic control could be quite effective because markets hadn't yet become global, transnational oligarchies are almost impervious to any form of national democratic control. One recent thinker, Danny Roderick, who's an economist and a political scientist, has argued that globalization has resulted in a trilemma of global governance. We have to choose between three different common goods. The global market, which is undoubtedly a common good because it comes with more prosperity for more people. It also comes there's a sort of dark side of it, but let's take at sort of face value the positive claim that can be made for it. So the global market on the one hand, the state and democracy. And Roderick says these three goods, global markets, state and democracy, can't all exist at the same time. You can at best have two of the three, but you can't have all three together. You can have democracy and the state. You can have perhaps, you know, the state and some form of globalization, but the state will not at that point be democratic. But it is very difficult to have all three of them, he says, together. He says it is all but impossible. So globalization, supranationalism, the distraction that Western democracies, but also emerging democracies like India had from the early part of this century, meant that this democratic turn in international law didn't quite take shape, and the window of opportunity that perhaps existed between 1989 and the financial crisis now appears to be closing as autocracies become more powerful and as democracies seem to be weaker and seem to also show in some cases dangerous trends towards greater autocratic or charismatic rule rather than liberal democratic rule. So we are at a difficult time, and one where I think the sort of worst case scenario is one where in the future the choice that we are really being offered is a choice between autocratic international law, as Tom Ginsburg calls it, that is the sort of international law that the rising autocracies would prefer, one where human rights or self-determination matter less. So between that kind of autocratic international law and an international law that is almost uncritically committed to a project of globalization that has quite clearly shown some limits, and that is too in crisis for different reasons. So if the choice is between autocratic and technocratic international law, I would suggest this isn't a particularly attractive choice in terms of values, and we need to find a way of putting again a truly liberal international order, one that does aspire to democracy, at the center of the agenda. And we need to move beyond, I think, this moment of political and intellectual and ideological confusion that some liberal internationalists appear to suffer from, where they don't quite understand the illiberal nature of the technocratic, or of a purely technocratic project. It has to be better than that, and it has to take political liberty and democracy seriously if it has to be a serious alternative to what is emerging on the horizon, which is autocratic international law. And let me conclude just briefly by making a remark about the difficulty, and this is again going back to Rousseau's question, the difficulty of coming up with a viable theory, let alone a practice, of a democratic international law. A democratic principle in international law would have, I think, to have two complementary dimensions. First, it would have to be directed at the members of the international community, and it would have to require that they become progressively more democratic, that they become progressively more respectful of the liberty of their political communities, as well as of the human rights of the individuals within those communities. So that's the first dimension of a democratic international law. It has to instill a sense that international law isn't neutral on the question of the domestic order of states, but that it does actually have a clear preference, and that preference is for domestic orders that are democratic in a substantive and not just procedural sense. But I think the second sense in which a democratic principle of international law would have to operate, the second dimension, is that it would have to affect its institutions too, and require that international institutions too act in accordance with a democratic ideal. Now, this is easier said than done, because the challenges, and they're conceptual as well as practical, of finding ways in which international institutions, given their size, can be truly democratic, those challenges are really phenomenal. And I think in spite of a lot of genuine, I think, support for internationalism or even cosmopolitanism, it is surprising how little thought is being given to this extraordinarily difficult challenge of how we can make international institutions more democratic in a sense that respects and embodies the values of political liberty. Because if we don't answer this question, then we go back to that problem that Kant identified and found insurmountable, namely that the moment you try to bring governance to the global level, the moment you try to come up with some sort of world state, you almost inevitably, he thought, end up with despotism. Was he right? Is there a way of creating global institutions that are democratic rather than despotic, or rather than displaying some tendency to despotism? I think these really are the great questions that will face us for the future, and particularly those of you who are students of international law are coming new to this field. So I think I'm going to stop now, and apologies again for the 15 minutes interruption. I hope you all had a chance to grab a cup of coffee, but it was probably my fault, but not deliberate.
Thank you, Guillermo. It was wonderful presentation, raising so many interesting questions to debate. I cannot agree more with you when you make this last appeal about the need to reimagine, to recreate the hope we all have back in 1990s, to have an international order based on values, and as you pointed out, on democracy in specifics. And on another hand, it links very well with the previous discussion we had with the students about whether we should insist on democracy in international relations and international law, or rather to maybe look separately in domestic constitutionalism from international constitution, from relationship between states internationally, do not really need to parallel the relationship between government and citizens. So when we speak about democracy in domestic constitutions, what we mean is the voice of the people, the separation of power, the control of the parliament, executive, and the judiciary, and all of that. But that doesn't really transpire into the relationship, let's say, between the Security Council, the General Assembly, and the International Court of Justice in the UN system. So why do we have this willingness to mix together what could be an ideal domestic democratic system, a responsible government and responsible citizens that respect each other and operate in a very cooperative way, with an international system which probably needs to operate in a different paradigm? So maybe instead of democracy in international law, we should talk about everything else: rule of law, human rights, respect to decisions, implementation, compliance with international rules, and everything else. But I worry that the moment we bring democracy into international law, we find it problematic, and historically problematic, not only today. I will go back to the UN Charter, which kind of avoided to talk about democracy per se, but it talked about everything else. It talked about rule of law, human rights, fundamental freedom, including in the human rights and fundamental freedom also the right to be represented in a government, freedom of assembly, freedom of speech, and all other freedoms that in their totality, we can argue, resemble democracy. So my question is, shall we let's put it provocatively, shall we abandon to talk about democracy in international law, but insist on everything else which I listed: rule of law, human rights, compliance with international obligations, good will, bona fide, and everything else? Thank you.
Yeah, I think that's the very important question, and I do agree with your concern that if we try to replicate at the international level what we have at the domestic level in order to make it democratic, we would end up with an international system that actually doesn't work and isn't democratic, because at that level, with 7 billion people and with individuals being so far removed from whatever New York or Geneva these decisions will be made, you couldn't meaningfully say that the global institutions, whichever they are operating democratically. So I think the risk is that replication, just trying to do the same, one doesn't work at the conceptual level, and then we end up with a system that doesn't deliver on any of its promises. So I think you're absolutely right that we do have to be very careful. The other point is that on matters such as collective security, I think there are very powerful pragmatic reasons for being quite careful about the language of democracy. The fact of the matter is that the preservation of peace is not just dependent on what most people in the world or in a country would prefer at any point in time. It's an extraordinarily complex goal, which is secured through a combination of legal prohibitions, prohibition on the use of force, but also realpolitik. And the Security Council has that realpolitik element in it, imperfect, we know, because countries like India should be there on a permanent basis too. But there is a realpolitik concern in the Security Council, which I think it should remain, even if it is reformed, at the heart of it. Because if it is to be effective, it has to reflect, to a degree, the reality of political and military power, if it is to be effective in preserving collective security. So I think I would agree with those concerns. It may also be that as technology develops and consciousness changes, that we will find ways of deliberating on a global scale that perhaps are not with us yet, but could be in the foreseeable future, that perhaps we should begin to think quite imaginatively of how to incorporate into a system of international governance. I'm actually, I know direct referenda and direct governments are not very popular these days, but actually I'm quite a fan of them. You know, the Swiss model, the Irish model recently, you know, they're quite interesting ways. And I'm sure that, you know, if there was a way of sort of sounding the entire world on what they think about climate change, I think people would get it right. You know, you will probably have the sort of answers that would end up putting popular pressure on the political agenda. Now, we don't yet have the ways of having a global public sphere where these conversations can take place, and let alone this deliberation, but we may not be so far away from it. So there may be ways in which, probably not within my lifetime, but I think within the lifetime of some of those who are listening, these things might become reality.
Thank you for those remarks, Professor. I see Professor Malhotra has a question, so I'll invite him to ask his question. I'll also invite others to ask their questions in the chat box or live. Professor?
If I may, just to reaffirm what Guillermo just said, I think I'm more hopeful in that way, that it will be artificial intelligence and reimagination of technology that might be one way to secure some sort of internationalization and globalization, as you pointed out, instead of going back and trying to fix or to remedy what didn't work, have been trying but didn't work for a long time. And here comes a good point, because you mentioned climate change, and climate change is, I hope, a unifier for all. And I don't mean only government, but also civil society and corporations. There is no bigger challenge to the world after COVID, let's say, than climate change. And when it hit strongly with the extreme weather event, with the flooding, the fires, and all of the rest of the cataclysmic, catastrophic events, there will be a point where the global decision-making will become important. There is no longer a chance to survive, I will put it bluntly, if we only rely on the traditional national borders, national decision-making, where parliament need to debate and to take decisions. And in that sense, I hope that will be really a transformative moment for international law as well, when the realization is made that national sovereignty doesn't help to solve global issues such as climate change. But let's student now enter into the question time. Thank you, Guillermo. Excellent presentation.
If I can just add before Professor Malhotra takes over, I had, in fact, just a comment to add to what Professor said as well. I think what happened in the Rio conferences in '92, which enshrined this very principle in as many words as common but differentiated responsibility. And I think a responsibility, an international responsibility, rests on shoulders of all nations. It differs in terms of how one nation needs to approach it, but the responsibility nonetheless rests on all nations. I think that remains the great equalizer of efforts towards one particular issue. I now invite Professor to ask his question.
Thank you. Taking Professor Popovski's point ahead, Professor, I would like to know your views on the aspect from a human rights and the rule of law perspective on the situation in Afghanistan. So the responsibility of collective responsibility in terms of imposing sanctions or safeguarding the rights of the victims in this situation, specifically those women or children or those who have fled their country. So what do you think? Because under Article 21 of the UDHR, it's the will of the people that sustains a government, that should sustain a government. So the will of the people is missing. What can international community do as if now, as the situation is unfolding even further, and what is the role of the international law, do you see, in securing the rule of law, the human rights of the people there?
I mean, it seems to me that at this stage, probably the best option for promoting those values is constructive, critical engagement with the Taliban. The reality is that they are exercising effective control over pretty much the entire country, that there is no appetite for another intervention, and probably wouldn't be wise anyway to consider that option. So that then leaves you with two choices. You either disengage completely or you have constructive critical engagement and try to see what you can achieve through that route. I mean, it seems to me that for the regional powers and for the Western powers and for those that are interested and keen to promote those principles of non-discrimination and self-government in Afghanistan, at present, that is the best policy option. It may be that within a few months' time, a different conclusion is reached because it is decided, you know, that the Taliban are just too extreme and there is nothing you can achieve within a sort of constructive engagement approach. It may be that that judgment would have to be revisited, but at this moment, it seems to me that that is the only sensible approach. But the options are limited.
is there any way to force them or to compel them to involve non-Taliban people, such as those who belong to the former Northern Alliance? Can the international community, in your opinion, do something so that at least some representative of the civil society or the people are there in the government also?
Yes, I think that pressure should be applied, and whatever leverage exists in terms of releasing funds, etc., should be used, and probably there should also be some clear red lines. I remember when the Taliban were last in power, humanitarian organizations were faced with a dilemma, which was whether to continue to provide emergency humanitarian assistance on a gender discriminatory basis or to pull out. I wrote an article titled "The Gender of Use Slogans" in the Human Rights Quarterly that was based on a memorandum of understanding concluded by UNICEF, I believe it was, and the Taliban government of the time, which I found completely wrong and unacceptable. That memorandum of understanding essentially accepted that girls would not be educated in schools under the Taliban, and that UNICEF would remain present on the ground on the basis that schools would only educate boys but not girls. And to me, that is obviously a red line. You know, no one would have accepted the presence of humanitarian organizations in South Africa during apartheid on the basis that they were only providing emergency assistance to whites but not to blacks. I think that, you know, that you just can't do that. But there may be other compromises where they will have to give ground to the interpretation of Islam that the Taliban subscribe to, although as we know, it's one that is very much contested by others. But I think there will have to be some accommodation, but there should also be some clarity about clear legal limits, not just moral limits. I think there are legal limits.
Thank you so much.
Perhaps Professor will agree that Taliban, the Afghanistan region remains the deathbed of colonial empires, as time would say.
That's extraordinary, isn't it?
Let me also share something rather slightly off the topic, but Professor mentioned supranationalism as a mindset. Now, a former scholar and visiting professor at King's was Sir Roger Scruton. Now, Sir Roger Scruton, as Professor now knows, and I see the smile on his face, it was a leading conservative thinker, and he also thought that conservatism, as a matter of fact, was a mindset. He's written extensively about this, and I thought I must return the favor since Professor was kind enough to share a lot of famous scholars with us. Another scholar which I would like to share and whose work has inspired me and offered a different vantage point of understanding the pre-charter era was the Kellogg-Briand Pact, and the book by Una Hathaway and Scott Shapiro, who essentially talk about the Kellogg-Briand Pact as outlawing war itself. They suggest this, and Professor Hathaway has even spoken for us. What they argue for and what they contend is that outlawing war seems ridiculous to us because ours is a world in which war has already been outlawed. It is difficult to imagine war serving any legitimate function other than a defensive one. Today, war is regarded as a departure from civilized politics. Before 1928, war was not a departure from politics, it was civilized politics. I also recollect what one Hans Morgenthau said on this, but the Kellogg-Briand Pact, fundamentally altered the nature of conflict by outlawing war itself. It reshaped the world map, catalyzed human rights revolutions, and enabled us to use economic sanctions as a tool of law enforcement, and ignited the explosion in the number of international organizations that regulate our daily lives. So what I essentially stress over here is the importance of international organizations based on the common values and now also natural justice principles. This is not a question, but I just wanted to share this because I found this idea to be profoundly enriching and also intriguing. Another point which I want to share here is the point on demagogues. And I recollect studying in my bachelor studies the tale by Socrates on the demagogue, which is the sweet shop's owner and the democrat who's the doctor. I think that's enriching experience of understanding how this relationship works. I don't have questions. The question which I had was addressed by Professor Popovski and you. I invite others to ask questions if there are any, but in the interim, if Professor could share his view on the evolution of state sovereignty from a Westphalian model to then R2P as a concept, as a counter concept to this. I've had discussions with Professor Popovski on this as well. And also now looking at it from the climate change perspective. So there is a the threshold of sovereignty is lowering, but there is also resistance against it. So I sort of seek your comments on this analysis of mine.
So I think the point that you made about the Kellogg-Briand Pact in some ways links to the question that you've raised. We sometimes think of international law and sovereignty as a sort of zero-sum game. You know, more international law, less sovereignty; more sovereignty, less international law. It's actually a bit more complicated than that. And the prohibition on the use of force is a great example of it. In a sense, of course, the prohibition on the use of force imposes a limit on the sovereignty of states. As I said at the beginning of my presentation, it's one of the defining limits of modern international law. You can no longer wage war other than in self-defense as a state. You no longer have the legal right or the sovereign right, if you ever had it, to do that. However, it also increases the freedom of states because it means that states can operate without the threat of war. And before the Kellogg-Briand Pact, it was quite common, in fact, until 1900, 1902, for powerful states, in those days obviously European states, to just send battleships to states that were in default of debt to foreign investors. It was, you know, gunboat diplomacy was one of the ways in which powerful states operated. Now that's unthinkable now. Argentina and a number of other states have been in default, but the idea that the creditors would send their battleships and aircraft carriers to threaten Argentina into paying is inconceivable. And the reason why it is inconceivable is because of Kellogg-Briand Pact, UN Charter, etc. But this limit on sovereignty on the one hand has a gain on the freedom of states, and generally the freedom of the peoples who live in those states, who can now think of ways of developing their policies when they find themselves in those situations where their government defaults on its debt. They can think of ways of developing their policy rather than just having to decide under duress. So that's more freedom, not less freedom.
Well, we will not hold you for very long and take your freedom away. I don't see other questions. So I think I'll hand over the floor back to you for final comments and remarks, and then we can close.
Well, I thank you very much again. I mean, I think probably my the best final comment is the one that I just gave in answer to your question. You know, that these are extremely complex questions, and the main concern that I have is that we could find ourselves boxed into this invidious choice between autocratic international law and oligarchic technocratic international law, as in a sort of international law that is only concerned about the functioning of global markets. And I think we have to do better than that, and we have to revitalize the liberal project of international law. I don't mean liberal in a sort of narrow sense. I mean liberal in the best possible sense, the noblest possible sense. And we have to do so quite urgently, I think, because politics is moving at a very rapid pace.
I would like to echo that, Guillermo. Indeed, as you said, we need to urgently reimagine international law with all what is happening around us, with COVID, with climate change, with all other challenges. So, and I agree, there is no way to just go back and try to recreate. It will be a different globalization. It will be a different cosmopolitanism. I will even argue it will probably be even a different liberal order, not what we had in the 19th and the 20th century. So it's really an exciting time to be an international lawyer, but also I notice in your comment a lot of Department of War Studies also talking, not simply an international law, but international law through the, as you pointed, the real politics of the time and the powers and how to deal with such huge autocracies as China and Russia in specific. So thank you very much from all of us for this exciting and excellent presentation. We really appreciate your time. We kept you for longer than 2 hours, and apologies for that. We wish to see you on campus in India one day. So I hope next invitation will be in person, and we will have you physically with us next time in Jindal Global University. Thank you once again. And
thank you very much.
Good evening, sir.
Thank you, sir.
Thank you
Thank
so much. Thank you.